Okay, riddle me this. What is common between Saadat Hasan Manto, Ismat Chughtai, Uorfi Javed and Milind Soman? The answer is that they have all at some point in their lives faced allegations of obscenity under Indian laws. The discussion around obscenity and the laws around obscenity in India has resurfaced with a recent Kerala High Court judgment. The court has discharged a women's rights activist who was slammed for being obscene and vulgar after she posted videos on social media showing her two minor children, one 14-year-old boy and an 8-year-old girl, painting on her semi-nude torso. But the High Court did not agree with these allegations and instead observed that nudity and obscenity are not always synonymous. Now, just to give you a background on where these obscenity laws actually come from, now Article 19(1)(a) of the Constitution guarantees the right to freedom of speech and expression. However, Article 19(2) lists down 8 reasonable restrictions on this right. One such restriction is decency or morality, and there are several laws that then embody this restriction in the interest of decency and morality. Now, within the Indian Penal Code, there are a couple of provisions which talk about obscenity. The first of these provisions is Section 292. I'll be taking you through these provisions one by one. It talks about the sale, hire, distribution, public exhibition, or circulation of any obscene book, pamphlet, paper, drawing, painting, representation or figure, or any other obscene project. So the ambit is quite wide. It also criminalizes import, export or conveyance of any obscene object, having reasons to believe that such an object will be sold, hired, distributed, publicly exhibited or circulated. Now, the punishment under these laws is a bit peculiar because it doesn't just list down a general punishment. So it says that if you're convicted under this provision for the first time, you could get a jail term of up to 2 years along with a 2,000 rupees fine. But if you're found guilty under this provision again, the jail term goes up. You could end up getting a sentence of up to 5 years imprisonment along with a 5,000 rupees fine. Now, the second such provision under Indian Penal Code is Section 293. This specifically talks about the sale or exhibition of obscene objects to a young person. But the young person here is a 20-year-old person. The law says that anybody who sells or exhibits or circulates any obscene material to anybody who is less than 20 years old can land up in real trouble. It provides for a punishment of up to 3 years long imprisonment and a 2,000 rupees fine for the first conviction. Again, this has 2 levels of conviction. For all the subsequent convictions, the penalty increases to a 7-year imprisonment along with a 5,000 rupees fine. The IPC also talks about doing obscene acts in public places and makes it an offence to sing any obscene songs or utter obscene words in or even near a public place. The punishment for such acts is a maximum of 3-month-long jail term with a fine or both. But if you've noticed, these provisions under the Indian Penal Code don't talk about the online space per se. So for that, we have Section 67 of the Information Technology Act. This provision talks about and provides the punishment for publishing or transmitting obscene material in electronic form. So it criminalizes publication or transmission of any material which is lascivious or appeals to the prurient interest, or if its effect is such as to tend to deprave or corrupt persons who read or hear the material. I'm quoting directly from the provision here, which you can see on your screens. But what exactly qualifies as obscene? To decide this, courts have come up with certain tests. So let me take you through these now. A landmark judgment on obscenity came from the Supreme Court in the 1960s when it upheld a ban on D.H. Lawrence's infamous novel, Lady Chatterley's Lover. The book was about the extramarital affair of an aristocratic lady and her gamekeeper, and at the time it was considered scandalous all across the world when it was published. It had descriptions of sexual encounters, contained the F word, and one of the significant moments of the book is Lady Chatterley and her lover orgasming together. Now, in India, 4 people who owned the Happy bookstall in Bombay had to face an obscenity trial for selling copies of Lady Chatterley's Lover in 1959. These were unexpurgated copies. Now, in its judgment, the Supreme Court upheld the ban on the book while clarifying that, and I'm quoting from the judgment here, sex and nudity in art and literature cannot be regarded as evidence of obscenity without something more, unquote. In doing so, the court adopted the Victorian-era hickling test, though, which led to obscenity being judged by the standard of someone who was open to immoral influences and was likely to be corrupted or depraved by the material in question. So the test focused on individual or isolated aspects of an entire work that could be deemed obscene, as well as its impact on vulnerable sections of the society. However, this approach included a wide range of material under the category of obscene. Of course, it brought a wide range of material under the category of what could be obscene. In 1969, a little more clarity came to Section 292. Subclause 1 was added to the provision saying that any object shall be deemed to be obscene if it is lascivious or appeals to the prurient interest. It would also be considered obscene if the item would have such an effect as to tend to deprave or corrupt persons who are likely to read, see, or hear the matter contained in the allegedly obscene object. However, in 2014, the Supreme Court switched from the hickling test that I spoke about earlier to the community standards test. This case was quite interesting too. The case arose out of a photograph. This was a picture of tennis player Boris Becker and his fiancée, actor Barbara Feltis, in the nude. This photo was initially published by a German magazine called Stern and was then picked up by an Indian magazine called Sports World, along with an article on them battling racism in Germany. However, a lawyer in Kolkata found the photo to be obscene and said that he was sure that the photograph would corrupt young minds, both children and youth of this country, and he felt that it was just against the culture and moral values of our society. The Supreme Court didn't agree. It ruled that the photograph is not obscene under Section 292 of the IPC. In doing so, the Apex Court moved away from the hickling test and instead applied the community standard tests. As I mentioned, the court explained that only those sex-related materials which have a tendency of exciting lustful thoughts can be held to be obscene. It asserted that obscenity has to be judged from the point of view of an average person by applying contemporary community standards. So that's how it's different from hickling test, which talks about vulnerable people instead. So the court asserted that a picture of a nude or semi-nude woman by itself could not be called obscene unless it had the tendency to arouse the feeling of an overt sexual desire. Applying this in the context of Becker's photo, the court asserted that it will have to examine the question of obscenity in the context in which the photograph appears and the message that it wants to convey. The court then concluded that the picture is not obscene because the message it wants to convey is that the color of skin matters little and love champions over color. The court noted that the picture promotes love affair leading to a marriage between a white-skinned man and a black-skinned woman. The court therefore held that, and I quote, while judging as to whether a particular photograph, an article or a book is obscene, regard must be had to the contemporary mores and national standards and not the standard of a group of susceptible or sensitive persons, unquote. It ruled that the photograph had to be viewed in the context of the message of interracial love that it wanted to convey. Since then, the court has applied these tests in different cases. For instance, to give you another example, in 2018, the magazine Grih Lakshmi created waves when it carried a model breastfeeding a baby on its March cover. The image was a part of a campaign called Breastfeed Freely, which aims to stop shaming women breastfeeding in public. The text on the cover read, and I quote, "Mothers tell Kerala, please stop staring, we need to breastfeed," unquote. The matter reached the Kerala High Court after some people found the cover obscene, but the High Court did not agree. It began its judgment by saying that what may be obscene to some may be artistic to other. One man's vulgarity is another man's lyric, so to say. It then applied the 2014 judgment and said that the picture cannot be considered obscene. The judgment spoke of Kama Sutra and the paintings at Ajanta caves and said that, and I quote again, "As the beauty lies in the beholder's eye, so does obscenity perhaps." That's all I have for you for now. This is Apoorva Mandhani for ThePrint. For more such videos, do subscribe to our YouTube channel and follow us on Twitter, Instagram, and Facebook.